Hi, Attorney Steve Vondran. We're back. We're talking about California litigation timelines. This is a overview, a cheat sheet, if you will, if we can use that word on live YouTube here. So it's a cheat sheet about California litigation, the codes and the timelines. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's head on over here. Okay, so let's see if we can back it up here. Can we back it up? Can we back it up? We're trying. There we go. Okay, so we're talking about some of the code sections, how a case progresses from the initial filing of the complaint down through your discovery period. So this is a video going to talk generally about some of these things. Okay, so your complaint gets filed. You see me way over here? Your complaint gets filed and you have 60 days to serve the defendants. 60 days to serve the defendants. That's California Rule of Court 3.110. California Rules of Court 3.110. If the complaint's amended and you add additional defendants, then it's 30 days to get them served. 30 days to get amended defendants served. And of course, you're going to file your proof of service with the court. Okay, so boom, knocking that out. The defendant has 30 days to answer or file a demur, which is sometimes what you see in a civil case. You're talking CCP 412.20. CCP stands for Code of Civil Procedure. Very good. CCP 412.20, 30 days to answer or demur. Knock that out. We did a video on motions, and I'm not going to go over that here, but basically the time frames for filing a motion, the response period, the opposition, and the reply period. Okay, so that's CCP 1005. If you Google that, if you're filing motions like discovery motions, motions to compel, those kinds of things, you're going to want to watch our video. Type in Vondran CCP 1005. That video will come up, talk to you about the time frames for filing your litigation. Okay, so we're not going to worry about that in this video. Discovery. Let's talk about discovery. Okay, so then after you get to the answer or the demur, you get through your amended complaints and a demur, and you finally get your case going, you want to engage in discovery. What's discovery? It's finding out the information you need to prove your claims or for the defendant to prove their defenses. So you get into this discovery period. So you start sending over form interrogatories, special interrogatories, requests for admissions, requests for production of documents. You may send some subpoenas. You may set depositions. These are the typical things your lawyers are going to engage in when you're involved in a lawsuit, state or federal. Really, there's different rules, but essentially the process is the same. You're trying to get that information to prove your case because you got to have evidence. You know, it's one thing to say something or allege something in your complaint, and it's quite another to have that evidence, that authenticated proof that shows what you're saying is true. That's how you get to the piggy bank. Okay, so you got your discovery. Let's talk about it. Either plaintiff may serve discovery 10 days after the filing of the complaint. So the plaintiff needs to wait 10 days after service of the filing of the complaint, 10 days after the filing of the complaint, before they can engage in these different discovery procedures here. Okay, so they must wait 10 days. Defendant does not have to wait. Defendant can send discovery anytime. So the minute you file your complaint, you serve the defendant, they can get right on the discovery if they want to. They don't have to wait around. The plaintiff does. There's a 10-day wait period. In federal court, you're going to find that this is a little bit different. Can relate to your judge and the scheduling orders and when things actually get going. So it's a different set of rules in federal court. We're talking about state court here. The code sections, let's get down to them here. These are the ones that are always hard to remember. You're putting your discovery documents together. You're like, what code section was that again? I totally forgot. You have your special interrogatories, CCP 2030.010 to 2030.090. Okay, there's your special interrogatories. Remember the rule of 35. You can only send 35 interrogatories unless you have a declaration in a complex case and you state that there's a need for more. There is a way to get more than 35, but the general rule is 35. We talked about that. You have your request for production of documents, what we call inspect, copy, test, sample. Let's say it again. Inspect, copy, test, sample. Your requests for production, you've got CCP 2031.010-2031.320. So there's your code section there, your handy litigation cheat sheet, okay? So you got that, and what's that? That's where you're requesting a lot of documents. I want to inspect things, I want to sample them, I want to see this, send me that, I want to copy this, those kinds of things, okay? So we have here, this is one that hardly ever pops up, but in the right case could pop up, is your physical and mental exams. You're allowed to take a physical or mental examination of your opposing parties. And I've never done it. I don't really know the exact context where you were, but maybe something where the mindset is at issue, whether they had the capacity to enter into a contract, maybe one way to look at that. So you have CCP 2032. You see how these keep going up? 2030, 2031, 2032, 2033. You see, so I tried to lay that out. Who's working for you? Attorney Steve's working for you. So you got your 2032.010-2032.650. That will have your code section telling you all about your physical and mental exams, if that is something in your case. Now admissions, CCP 2033.010 to 2033.420. There's your admissions. That's asking someone to admit or deny something. Admit that you did this. Admit that you were there. Admit that you put the banana peel on the ground and that's what the person slipped on. Admit you caused their injuries. So you're trying to get them to admit or deny things, okay? Trying to catch them in a lie, basically, so you can hit them for attorney fees at trial. Okay, so there's your admissions. And then you have your form interrogatories. Remember up here we talked about your special interrogatories. Here we're talking about your form interrogatories, CCP, Code of Civil Procedure 2033.710-2033.740. And your form interrogatories, those are the interrogatories that you're going to send out that are just in a pre-created judicial counsel form. You can look it up on the internet. There's no charge. They give them away. It takes you, 15-20 minutes to fill out. You ask all these questions, you check the box, and then your opponent, your opposing party has to go and present all that evidence and get all that information together for you. Where they work, where they grew up, school, convictions, insurance, all these sort of what we call form questions. So there is your basic discovery tools, let's call them. Those are your basic discovery tools that you're going to use in most cases. Again, you have your depots, and the defendant can get on this anytime. Plaintiff has a short wait period. Okay, so we talked about that. You're good to go on that. Your subpoenas, we talked about subpoenas. You can send out a subpoena. Attorneys can send out subpoenas requesting documents, let's say like a medical provider. You have a personal injury case. You want to get the medical records. You say, well, it's over there. It's one of these hospitals. It's a clinic, those kinds of things. I got to get the info. Send out a subpoena, and that will be covered by your section CCP 2020.410 to 2020.440. Now, all these codes aren't exclusive, and under California law, there's usually a lot of different codes that impact these. I'm just giving you the general code section, so don't say, well, that was it. That was the only one. No, there's lots of different code sections that impact discovery. So when I'm giving you the basics so you can have a point of reference. Okay, so that's your subpoenas. The other party's got to comply with those. If they don't comply, they end up being held in contempt of court. If you file a motion to compel, hold them in contempt of court. So that's your subpoena. What else? Depots. Let's go to your depots again. These are things you're going to have pretty much in every litigation case. You're going to want to take the deposition of the other party. That's where you're sitting down face to face asking these questions. Okay? Plaintiff again must wait 20 days after service of process to serve the depots. You have depots by written question. You also have phone depots. Okay? So, and you have some territorial requirements where you serve defendants within 75 miles of their residence or within the county where they reside, where the case resides, within 150 miles. Okay, so you can blow it up here. I'll give you the code sections. You can see them there. You can see them here. If you want to look at them, you can see it here. I've got the code sections for you to give you that starting point for your research. Okay, so there's your depots. 30 days to respond to written discovery. Whoops, I forgot it over here. 30 days to respond to your written discovery. And so when you send discovery, the other party has 30 days generally to respond. Sometimes as attorneys we give each other extensions, so that period goes on longer, okay? Expert witnesses, we're going to do a little separate video on that, so I'm not going to go into that now. It's kind of its own topic, expert witness videos, so we'll leave that for another time. But you got your code sections, you got your phone depots, and what that is you can basically set up a deposition where the deponent has to show up at the court reporter's office, let's say, and then you can take their deposition by phone. It's kind of neat. Most people don't know about it, but it's a neat, in effect, or cost-effective way to take depositions when you have a lot of parties and a little bit of money. So you got your phone depots. That's CCP 2025.310A. Okay, so you have that, your 30 days to respond. When you're mailing things, you're going to have to add on additional days, additional 5 days. If you're out of state, there's more time that you have to add. I won't go into that. And you have your discovery cutoff, usually 30 days before trials, 15 days before an arbitration. You have your motion to, what do I have? Oh, so you can get it, you can file motions to extend your discovery cutoff, or you can stipulate with the other party. Sometimes they're willing to stipulate, sometimes they're not. That's where the art of negotiation comes in, okay? And then finally, what do we have? Last day, 90 to 100 days before trial, time for motion to compel. So you want to just keep in mind always your trial date and sort of the last date when you're able to file discovery requests and have time enough for a motion to compel. That's probably 90 to 100 days before your trial, okay? Finally, you have your CCP 998 offers. We're going to do another separate video on that. It's an important topic. CCP 998 offers to compromise your case. You can do those up to 10 days prior to trial. And that, again, that's in the Civil Code, CCP 998. Look that up, or we're going to have a video on that. Last day to hear motions, discovery motions, 15 days before trial, CCP 2024.020. So that's a basic overview of the litigation process, some of the important code sections you're going to be needing to know, to look up, to cite in your documents. Those are some of the tools, some of the tricks of the trade from Attorney Steve Vondran here with you. So if you have any other questions, check out our website at askattorneysteve.com. That's askattorneysteve.com. If you have litigation cases, step-in cases, you need someone to step in, the judge has ordered you to get an attorney, you got state, federal case, you got an adversary proceeding, you need representation, you got a broker administrative hearing, give us a call. We are happy to help and look forward to working with you. Okay? Make sure also you subscribe to our channel so you can get these updates coming to you regularly. We appreciate your time. We appreciate you following us, and we look forward to working with you. Thanks a lot.